Thanks, Pam. I appreciate it. So welcome, everyone. I want to talk today about a topic that is actually near and dear to my heart, which is discipline and suspension. So what I'd like to share with you is that I actually have two children. I have a daughter that is 16 years old, and I like to say that she's diagnosed with girl drama. But I have a 19-year-old son who has autism and behavioral challenges. So this is definitely a topic I enjoy speaking with families and professionals. Also, I want to let everyone know that at the end of this presentation, we'll have information about our agency, which is Starbridge. We'll also have our phone number. So we will take questions at the end of the presentation, but if you have very specific questions in regards to either someone you're working with or a family member, your own child, we'll encourage you to call in and maybe get some one-on-one support, but we're also happy to answer questions for you as well. So when we talk about suspensions, we're going to talk about different types of suspensions. The first one is a short-term removal. So usually a short term is 5 consecutive days or less. Long-term suspension, we're going to talk about that more in just a minute, is more than 5 days. Usually when you have a short-term suspension, most, but not all, take place in school. And so what an in-school suspension is the student usually remains within the school building. They go to school, but they receive instruction in another room for disciplinary reasons. Now, if it's a student with a disability, they have to continue to progress in the general education curriculum, and they need to continue to receive their services as specified on their IEP. So if they get speech therapy, if they get consultant teacher, they would still need to be receiving those services as well. The next one is the dreaded out-of-school suspension. And I love this picture because I am not a fan of out-of-school suspension. We see this young man, and it looks like he's on a vacation day. So I don't think out-of-school really helps or supports anyone. He's watching TV. And usually for students out of school, it's usually something has happened, and we're going to get into much more detail about specific reasons why someone would get out of school or long-term suspension. If they are a student of compulsory age, and we're going to talk about what that is in just a minute, then they still need to receive instruction. Instruction usually needs to start within 1 or 2 days of being suspended out of school. I will tell you that it's almost impossible for it to start immediately. Usually what happens is districts contact their tutor, their district tutor. They set up arrangements. Depending on the reason why the student was suspended, they may come to the home. They may have to actually then come to school to get their instruction, or they may go to a library. So with suspensions of 1 to 5 days, what we'd like to see, and what's good practice, is you should get some type of written notice for the parent. You should be able to talk and meet with the teacher or with the principal to find out what actually happened. There should be a phone call home to the parents and maybe even a conference and talk about what happened and what we can do to change things. And again, if the student is between the ages of 6 to 16, we have to set up some form of alternative instruction. So I wanted to show you an example of what you may see if a student is suspended for about 1 to 5 days. So up here you'll see the name, who was the teacher, what time did it happen. This is all good information, the place where it happened. So, and they should be able to tell you what the inappropriate behavior was that caused the suspension. Now, some of these are, well, leaving food and garbage, I think that might not really be a reason for suspension, but let's go to inappropriate language. What was it? What were the words that were said? And you should know the time, the place, the teacher, what happened. A lot of times we have families give us a call and they said, my son was suspended for 2 days. He was being non-compliant. And I always say, what does that look like? Because some of these are vague. Well, throwing objects. Did someone get hit? What was the object? Was it heavy? Was it light? Was it a desk? Yelling, teasing. Again, I want more information. The more information that we have, the better we're able to help and support the student, the teachers, and all the other kids.
Laura, excuse me, before you go too far, we do have sort of a basic question.
Sure.
That you mentioned things that were covered, that were protected under the IEP. The question is it the same for 504? So can you talk about how discipline and suspension relates to students with and without disabilities and how the protections come into place under IDEA?
Sure. So if a student has an IEP and they receive supports and services, so usually, it may be speech therapy, OT, PT, consultant, teacher, they would still receive those services whether they're in or out of school, in and out of school suspension. When we get into a little bit more of, and we're going to cover this today in a few more slides, when we start talking about manifestation, we do group in students who have 504 plans. But what I would say is if it's a student with a 504 plan, usually a 504 plan has accommodations on it. So if a student is in school suspended and they are taking a test, they have a test to take that day and they get time and a half to take that test, if they're in school and they're suspended, they should still get time and a half. So the difference really is for students who have IEPs and 504s, you should still be able to have access to your accommodations or whatever supports and services you have. And then when we get into manifestation, students with 504s should be grouped into determining, and we'll get more into it, whether their disability came into play. And I hope that answers the question. So I'm going to continue. So what we know is every student has the right to an education. So whether you're a student with a disability and you have a 504 and IEP, if you are between the ages of 6 to 16, you are of compulsory age. That means we still have to educate you. So if you are a 7-year-old child with no disability, no 504 plan, and you get suspended from school for hitting another student, we still have to send a tutor either to your home or set up tutoring at a library or another location. You still have to be educated, and that is the right of all students. Where it gets trickier is if you are a general education student and you are 17 years old and you get suspended for swearing at a teacher. We do not have to. The school does not have to provide you with tutoring. If you are over the age of 16 and you have an IEP, it's good practice to allow the student to still have access to their education and support them with their supports and services. So when we talk about alternative instruction, and we talk about home tutoring or getting tutoring at the library, the minimum that students from grades K through 6 get is 1 hour a day. And I will tell you, I have never seen more than the minimum. So they have to give you the minimum. And for students in grades 7 through 12, they get 2 hours a day. So they get about 10 hours a week. So you can see that if it's a student who struggles in school and you are in high school, getting 2 hours a day may be very challenging for you to be able to keep up with the curriculum and the workload. So when we talk about a disciplinary removal, that is a removal of a student for disciplinary reasons that places them anywhere. And even if a student is sent to the hall, it's considered a removal. So if we have a student who has some challenging behaviors and we find that they're very disruptive, and let's say they're very disruptive every single day during ELA, and we send them to the hall for 5 to 10 minutes, what we're discovering is that that student is being removed from instruction. What we also may start to notice is that student may not seem to be doing very well in ELA. And so it's really good practice that anytime a student is removed from the classroom for whatever reason, they're being removed from instruction, we need to have conversations with families. We teachers and principals need to be talking to families, and we need to be brainstorming what is going on. Maybe that student really struggles with reading and they act up during ELA time. But the more that they're removed from that time, the less instruction they get, and then they still will continue to struggle in that class. So I like to say a removal is a removal. Out in the hall is a removal from instruction. Going to a get up and get ready room is a removal from instruction. And we need to let parents know, and we need that documented. So if your child's coming home and they're telling you that every day they're, having to sit out in the hallway for a few minutes, I want you to follow up and call the teacher and find out what's going on and what we can do and how we can support that student. Okay, how many had anxiety over seeing this come up on your cell phone? I've had this several times too. We get the dreaded, the school is calling, and we're going, oh my gosh, what is happening? How many times, and I would like you to think about it, have you been called to say, Johnny's having a bad day, can you please come and pick him up? What I want to say is anytime a student is sent home, whether it's for the last 10 minutes of the day or you're getting called at 8:30 in the morning to come pick them up because they're having a bad day, we need to just start asking the school some tough questions. And the question would be, is my son or daughter or my child being suspended? If the answer is no, they're just having a tough day, you need to come get them, I really think it's important to start having a conversation with what is really going on. When I work with families, a lot of times they get this call, they go to school, and by the time they get to school, their child has already calmed down and they're probably ready to go back. They could be ready to go back into the classroom. Unfortunately, they think you're coming to pick them up. The reason why we want to ask if they're being suspended is because when a student is suspended, you need to fill out a report, and the school needs to calculate that they're not, how many days that they're missing from school. And we're going to talk about what happens when a student has been suspended for 7 or 10 days throughout a school year. And they don't have to be consecutive, but I'll get into that in just a minute. If they are being suspended, then we document it. A lot of times we have students suspended 20 or 30 times throughout the school year. There's no record because parents are just coming and picking them up because they're having a bad day. And the 10-day actually triggers what's called a manifestation. And that's really important information. Now, if your child is truly having a bad day, the school and they're out of control, we've had some parents say, are you suspending them? And they say, if you don't come pick them up, we're going to have them mental health arrested. As a family, you need to make a decision about how you want to handle that. But I really want you to think about what a bad day is. You don't have to come pick them up if they're having a bad day, but it should prompt some meetings and conversations about, we're having a lot of bad days, what does this mean? Again, if you're asking, are they being suspended? If they say no, then they have a choice. They can keep them and continue to work with them, or they can suspend them, and we're going to document that, and that's going to trigger some other supports that could come into place. So we're going to talk about some reasons for suspension. So when we look at this picture, for some people, they may see a student being insubordinate. For another, I may see a student who has sensory issues and something's too loud and they're having a hard time. We see this could be labeled as disorderly, but again, maybe it's a student who's fidgety and they need to play with rubber bands. Violence, someone getting hurt, physically hurt, and putting your hands on another student could be labeled as violent, and that's really important to understand when we start to use those words and what that looks like. Here's some kids. They could be kind of messing around, but it could also be labeled as disruptive. And the reason why I showed you those photos is, and had those words, is those words are typically used in your school's code of conduct. A code of conduct is written and it talks about conduct that otherwise endangers the safety, morals, health, or welfare of other students could violate the school's code of conduct. So I want you to take a moment and think about, do you know where your district's code of conduct is located? Usually, most districts send it home at the beginning of every school year, and students sign it and send it back. I am a repeat offender. I have not read mine, but I probably sign it and send it back. Most districts, you can find it on their website. Some are harder than others. If you don't know where it is, you can always call your local school and ask, where you could find that. Most are on their website. But it's good to know, and it's good to talk about and to go over with students, because you will hear the terms, they violated the school's code of conduct. So it's important to talk about what those words that they use, insubordinate, disorderly, and then get some meaning behind those words. Okay, we're going to talk about school bus suspension for a few minutes. So technically, can you get suspended from the bus? Technically, yes. But if you are suspended from the bus, the school has to make a decision. You cannot be, as a parent, forced to drive your student to school. If they are suspended from the bus, you can say they either have to do another form of transportation, district car, a smaller bus, and take your child, or they have to then suspend them from school because that may be their only way to get to school. So as families, you can push back and ask, are they being suspended from school? No, they're just suspended for the bus. And you can say, okay, great. Now, what will be the other form of transportation that you will be providing? Again, a district cannot mandate a parent to transport a school. I have seen situations, though, with students with disabilities who have transportation on their IEP and they live within walking distance to the school, and they have gotten suspended from the bus. If you live within the district's walking distance, then you may have to then transport, but that is only one of the few unique situations. So again, you can ask if they're being suspended from school. If the answer is no, then you need to ask will they provide transportation. They do not have to. You do not have to provide them transportation. You don't have to transport, but then they need to make a decision if they're going to actually suspend the student. Most of the times, the infraction isn't enough to suspend the student from school, so they usually provide another form of transportation. If you are in this situation, I would suggest not only calling your director of transportation, but as well as your CSE chair. They can also help inform that director of transportation what that student's rights are. So if a student has an IEP, they have procedural safeguards, and that notice has to be sent to the parent if they're suspended. They're still entitled to what's called FAPE, and that's free and appropriate public education. They have a right to what's called a manifestation determination, and I'm going to get into that in just a minute. They have a right to a functional behavior assessment and a behavior intervention plan. They have the right to what's called expedited due process hearing. That means to have it within a timely manner, so you shouldn't be waiting 2 months. And there are protections for students who are presumed to have a disability, including expedited evaluations, and I'm going to get more into that at the end of this presentation as well. So remember when earlier I had showed you a picture of what a potential suspension notice or disciplinary removal notice would be? Those are important to have because they can help you set up a pattern of removal. So if we have a time and a place and a teacher, we want to start to look at, Is there a certain time that this happens for the student every day? Is it in the lunchroom? Is it when there's a substitute teacher? Is it right after PE? Is it when the student doesn't have recess? What is it? And we want to look at that to determine, is there a pattern of removal? What is happening? And again, we want to start looking at what can we do to help and support the student. So superintendent's hearings are part of the process when a student is long-term suspended. And a superintendent hearing is usually handled first with students with disabilities, and it's really a fact-finding process. For example, did your son or daughter bring alcohol to school? Yes or no? Did your son or daughter allow someone to purchase their ADHD medication? Yes or no? Once you had the superintendent's hearing, did they do this? Yes or no? Then the next will be a manifestation determination. Then there'll be a penalty determination. And then they're going to see if they need to develop some interim alternative instructions by the CSE. So I know we've been using a lot of words and we're talking about a manifestation determination. And what is it? Well, it's a review of the relationship between the student's disability and the behavior subject to disciplinary action. And I'm going to go into deep detail about what that really truly means. So the first part is you really want to look at, was the behavior caused or did it have a direct and substantial relationship to the student's disability? I use this picture for a very specific reason. I was working with a family that their son had Tourette's, and part of one of his tics was he rolled his eyes. The teacher felt that it was very disrespectful and wanted to suspend the student because they felt like they were being very disrespected. When we look at this and say that the student has Tourette's, is their eye rolling direct and substantial relationship to the student's disability? I think we can very easily say yes, it really is. So that's just one example of, is it a manifestation of the student's disability? Yes, yes it is. The other question that we need to ask when we're looking at if it was a manifestation of the student's disability is, was it a direct result of a failure to implement the student's IEP? So what they're looking for is an example. Let's pretend we have a student who has an IEP, and they come into the room one day and they discover that they have a substitute teacher. The student has anxiety and they have ADHD, and on their IEP they're allowed to leave and go see their counselor once a day from that class if they're feeling anxious. The substitute teacher tells the student no, that they're not allowed to leave and they have to finish all their work. The student becomes upset, yells at the teacher, and storms out of the room. So would this be a direct result of a failure to implement the IEP? I'm going to say it probably is, and that's usually a good result. So if it's something that's written on the student's IEP and we fail to implement it, it can be seen as a manifestation of the student's disability. And I'm going to tell you what's going to happen next. So part of a manifestation meeting is it's a formal meeting. So when a child who is recognized by the school as being a student with a disability and has behaviors that are in violation of the school's code of conduct, and a suspension or a change of placement is suggested, the district is required to have a formal manifestation meeting to determine whether or not the behavior is a result of the child's disability. And remember, they're going to ask those two questions. Was it a failure to implement the IEP, or was it caused, or did it have a direct and substantial relationship to the student's disability? So if the manifestation team determines that the code of conduct was a manifestation of the student's disability, The CSE we should look and see, do we need to have a functional behavior assessment, or do we need to update or modify an existing one? They need to return the student to the placement from which the student was removed, unless the parents in the district agree to a change of placement, or unless the student participated in dangerous behavior, drugs, controlled substances, weapons, or there was serious bodily injury caused the removal. And we're going to get more into those a little bit too. So let's say that the student did not, or they have an FBA. We want you to ask questions. If your son or daughter is being suspended, we want to ask, do you have an FBA or a functional behavior assessment? If there's one, you'd like to see a copy. You want to ask when the last time it was updated. You would like to ask, is it positive? Is it proactive? Is it being followed?
Excuse me, Laura, can I jump in for
Sure.
just a quick question? What you're talking about with regard to the manifestation determination, the question is, is this only for 5+ day suspensions, long-term suspensions, or would this be put into place for a short 1 or 2 day suspension?
That's a great question. Actually, when you do a manifestation determination, it's 10 days. The student has been removed from school for a total of 10 days anytime throughout the school year.
Okay, so for a shorter suspension than if it's a 1 or 2 day suspension, the district does not go through this formal process.
No, but if the student is suspended 2 days in September and 2 days in October and 5 days in December, that student has one more day before they're suspended, before they will have a manifestation determination.
Okay.
What I will also tell you is, that's what the regulations say. In a perfect world, I would love to see that a student who maybe is suspended 2 days, 2 days, 2 days, 2 days before it even gets to 10 to start talking about it. Unfortunately, that's really the trigger, and it has to be a documented suspension. So if that student is sent home the last hour of school, that's why you want to ask, are they being suspended? Because there's no half-day suspension, partial day suspension, 2/3 of a day suspension. The minute they are suspended from school, it counts as a whole day.
Okay, thank you. And for I want to just let the audience know that there are some other questions have come in, which I'm going to pose to Laura when she finishes the formal part of the presentation. So I'm not ignoring those. It's just that this one seemed as though it needed more immediate attention. So
no, thank you. That was a great question.
Okay.
So when you go through this process, let's say they decided that it was not a manifestation of the student's disability. You have the right to agree or disagree with that, and that's called your due process rights. And you can go to a hearing. So you always have next steps, and that's what's always important to know, that you have the right to disagree, and there is a process put in place, and that's your due process rights, and the school should be providing you with that, and you are able to file that to say you disagree and why you disagree. So now, earlier I had talked about there's some exceptions to long-term suspension, and a few of the exceptions, especially for students with disabilities, are I just noticed this has 3 I's, or like 3 L's in front of it, illegal drugs, and that is one of them. The other one is serious bodily injury, so that's when a student gets hurt. Now, I have worked with families in the past where a young man was accused of stabbing a classmate with a pencil, and I heard that, and it's very alarming to hear. On working with the family, and I actually, for this one, we're not always able to attend, but I was able to attend the superintendent's hearing. And remember, the superintendent's hearing is a yes or no. Did the student do this, yes or no? And talking with the school nurse, I was able to ask, when the student came down, the family had said, you know, he poked her with a pencil. He just poked her. So in asking questions to the school nurse, I said, did the student come down and require medical attention? She said the student did come down. She offered medical attention. They did not take it. I said, did the pencil, did it tear the shirt? She said, no. I said, did it leave a mark? No. Did it require a Band-Aid? No. Did it require ice? No. So then I was able to say, it sounds like she was poked. But again, it was written up as the student had stabbed another student with a pencil. Very important to get specific information. Again, my son yelled out a name. What was the name? What was the word? How was it used? My son threw things. What did they throw? Did anyone get hurt? We want to start asking and pulling out that information. Sometimes in talking to families, we will discover that a student, even due to their disability, had harmed another student. And if that happens, for example, they would say, well, my child was accused of biting another student. Well, you know, did they bite them? Did it break the skin? Yes, yes. Then we would say, yes, that could be considered serious bodily injury. And that's also our job, to help you be able to navigate that and let you know how that will be viewed. And we will, if you called and you had these questions, we're going to ask you some questions and help you get to what was the behavior and what happened due to the behavior. Weapons is another one. For example, you know, bringing a knife like this to school could definitely be deemed as a weapon. There are very specific things in the regulations that say what sort of a knife could be. So for example, the Swiss Army knife that a lot of our Boy Scouts have is technically not long enough in the regulations to meet the requirements of being a weapon, but we have experienced students who get suspended for having a weapon. So when we talk about getting expelled, students without disabilities can be expelled for up to 1 year. Now, I will tell you, I have seen some things written by the Commissioner of Education stating that state ed is not a fan of seeing students out of school for a year, and we can all know that can be very challenging. So they've given some guidance for schools to say, and I'm going to give you, this was one of the examples, a student without a disability had been caught on school grounds with marijuana, and they were going to expel them for up to 1 year. The parents actually filed a complaint to the Commissioner of Education, and the Commissioner of Education actually said it was the student's first time infraction. They really hadn't been into any serious trouble, and I'm not talking about like little minor in-school suspension trouble. And they felt, so they shot that down and said, the student, you know, that's excessive. So that's the good news. Now, superintendents do have increased authority to suspend or remove a student with a disability to what's called an interim alternative education setting for up to 45 days. So it would be another placement, and that could be home. It could be at home. It could be to an alternative location to receive that. For offenses relating to serious bodily injury, illegal drugs, controlled substance, or weapons. If they decide that returning the student to regular placement is deemed too dangerous, then they need to have an expedited due process hearing to extend the removal for up to 45 days. And vacation, holidays, and summer breaks do not count towards a 45-day removal. So, for example, a student who, let's say a student really did stab another student with a pencil, and it caused the student it broke the skin, it bled, they required a stitch. Whether they were a student with or without a disability, they could go beyond those 45 days. But for students with disabilities, after the 45 days, they will probably look at a change of placement and say, is there a more appropriate setting to help and support this student so other students aren't harmed? So when you're going to your superintendent's meeting or the manifestation, usually what happens is the superintendent's meeting takes place first, and usually what happens is you talk, did it happen, yes or no? People move out of that room, and then the people for the manifestation meeting move in, or you get up from one room and move to the other. They're usually right back-to-back meetings. We want you to make sure you know the date and the time and the place of the meeting. We want you to dress appropriately in a manner that demonstrates respect for the importance of this meeting. This is a very important meeting. We want you to talk to your child about the importance of this meeting, and to go in there, and we want to be respectful to everyone at the meeting. You also want to ask for a copy of your son or daughter's IEP or 504 plan, or if they have a functional behavior assessment, you want to ask for that and try to get that prior to the meeting. So if it was a manifestation of the student's disability, they get to return back to their prior placement or whatever their least restrictive environment, unless the district and the parents agree to the change, or serious bodily injury, weapons, or illegal drugs or controlled substance were to take place. So we have seen students who have brought some serious weapons or harmed other students, and what happens is that because of the nature or the severity of the bodily injury or the weapon, or the difference, there is a big difference between bringing marijuana to school versus bringing heroin to school. So based on that, the school district may suggest an alternative placement to that for that student. Now, we had talked very briefly in the beginning, but there's something called unique circumstances. And unique circumstances is when it's a federal law, and it encouraged careful consideration of students and the situation prior to suspending or determining a change of placement. So what the law says is schools personnel may consider any unique circumstances on a case-by-case basis in determining whether a change of placement is appropriate for a student with a disability. So what does that mean? Let me give you an example. Let's say your son or daughter has been bullied for months by another student and one day swears at the other student. As a parent, you'd want to be prepared to discuss the fact that these are unique circumstances, that the swearing was really caused by the amount of bullying that they were receiving, and they should use that information into really helping determine should the student really be suspended. And I do see this a lot around bullying issues. So especially with students with disabilities who are continued to be bullied, and they may lash out or hurt another student because of that. Again, depending on the severity of what happens to the other student, but let's say they push another student, if you can bring up or talk about that information, they need to take those unique circumstances into consideration. And I actually just read some current information on students who have IEPs, that schools, if you feel that your son or daughter is being bullied and it's impacting their education, the school must, at that student CSE meeting, review that, and any refusal to review the bullying and the impact on school is actually violating the student's right to a free and appropriate education. So there is something else called a basis of knowledge, and this is when a student is presumed to have a disability. So really a basis of knowledge is that all it has to be is the parent of the student has expressed a concern in writing, or they could have expressed orally to someone who is considered a supervisor or administrative personnel, or a teacher, that their son or daughter has a disability, and nothing was ever done by that. So for families, if you continue to express that you have a concern and you want their child evaluated, we always say document, document, document. Always, if you're concerned that your son or daughter may have a disability, we say send that request in writing, and always send it to the CSE chairperson of your district. If you do not know who that is, you can call your district office and ask for their name. Most of the time you can find it on their website as well. So again, it's whenever anyone, the parent or another school personnel, has expressed a concern about the student's behavior or their learning, and they're in need of getting supports and services. That's called a basis of knowledge. So if the behavior is not a manifestation of the student's disability, then they are actually looking at a suspension or removal may be imposed to the same extent as a non-disabled student. I will tell you that students who are classified as having learning disabilities and like they may act out or swear or become upset, it's harder to say that that is a manifestation of the student's disability when it's a learning disability. Those are much more challenging to prove. Students who have ADD or ADHD, autism, mental health issues, we usually find that those are ones that are easier to prove. So when you go to the meeting, we want you to stay focused on determining the most appropriate supports that will also help the student. What are the skills that the student needs to be successful at school? So if they continue to get suspended for being disruptive or acting out, we always like to say, is it there a skill deficit that we need to teach the student? If the student is long-term suspended or even suspended for the week, what is the re-entry plan? How do we help the student come back into school and be successful? If we don't change anything, it's very likely that the behavior will occur again. So I think we have a lot of questions.
You are absolutely right, Laura. There are a variety of questions. I'm going to start with the ones that are more of a general nature. There are some pretty specific questions, and we'll see if we have a little bit of time to get to those. But as Laura mentioned early in her presentation, we encourage you to call Starbridge to get individual assistance for situations that relate to your own child or to a student that you're working with. We will try to address some of the things in a general nature, but we do have supports available for more specific concerns that you would have. And sometimes a webinar isn't really the best opportunity to get those concerns met because there's a fair amount of back and forth that you would have with an individual parent education specialist to kind of dig deeper and get into those issues that are pertaining to your child. So let's start with some of the general ones.
Okay.
Early in the, this is from kind of early in the presentation, and I think you probably have used this term more than, at the time, the person said twice you've used the term good practice. And so does that mean that that's what they should do, but not necessarily what's required by law? So can you kind of talk about the distinction between what the school is obligated to do based on the regulations and what they should do based on what's best for the student?
Well, you're exactly right. Good practice is what I think they should do versus what they're required to do. So again, this is a really tough thing. I'll go back to almost the student is having a bad day. What I have seen is some districts go, well, we don't want to suspend the student. They're just having a tough day. We want them to go home. So I go back and forth with this one. I get that, but what I tend to find is what the regulations are is whenever you're sending a student home, that is considered a suspension. And what the New York State Department of Education says to schools is we need to be accountable for these students. We need to be accountable for their learning. So if we're just sending them home for a bad day, if we don't suspend them and document it, we have no way of knowing how often it occurs. It seems harsh, and it seems sometimes tough as a parent to say, suspend my child. But I cannot tell you how many times we've seen students who are like, yeah, they just ask them to go home, they're having a tough day, and it's been 10 times this year. Well, to me, that's a pattern. And what is going on? So the law or the regulations, you really need to suspend them. The schools sometimes are saying, well, we just don't want to do that. You should. When a student is sent out into the hallway, there's no requirement to actually document that, but good practice is you should be documenting that. And the teacher should be writing that up and sending it to the principal, and they should be discussing that with the parent, because then we're starting to look at a removal. So there are a lot of things that sometimes we go, oh, we just don't want to pick on the student, or we just don't want to stress them out more. And documenting things is the best way that we can have a clearer picture to go, what is really going on? Is it this one class? Is it all day long? Why is the student having this behavior? And how can we help them? So yes, so without getting into everything that we covered, there's the very specific regulations are around superintendent's hearing, manifestation determination, rules and regulations for students who have disabilities, compulsory age are regulations. I'm trying to think. Tutoring. Now, tutoring, there's a little bit of leeway because let's say a student was suspended for 2 weeks. Um, the best thing to do is for tutoring to start immediately. Unfortunately, to get that set up may take 2 days. You should not be 5 days into a 2-week suspension and still not have tutoring set up. That's an issue. That's a true compliance issue.
Okay.
So,
And we
go ahead.
had a specific question about tutoring. And so should a tutor be put into place for just a 1 or 2 day suspension, or is there a minimum number of days before the school is required to provide a tutor?
So this gets a little tricky that there's actually, it says as soon as possible or to expedite as quickly as possible. I like to say here's where we go. Good practice is 1 to 2 days. So if a student is only suspended for 1 or 2 days, I'm going to tell you that you will probably not be able to get tutoring set up. It's just not logistically possible to do that. If a student is suspended for 5 days, by the 3rd day you should have some form of tutoring. If not, as a family, I would want you to call the CSE chairperson. If it is a student who has a IEP, if tutoring still is not set up, I would have you call the regional associates, and they are compliance officers for students with disabilities for New York State, and they could very quickly help your school resolve that issue.
Okay, great. In your experience, are districts good about initiating a manifestation determination, or do parents typically need to do follow-up? I'm thinking that what they're asking is if a student was suspended, are they always doing the manifestation if the student is classified with a disability, or are there times where that step is skipped?
I haven't experienced the times that this step is skipped if they are documenting that they're actually getting suspended, because that 10 days, the 10 cumulative days throughout a school year is that trigger. Where I find that they're not catching it is when they're asking for students to be picked up because they're having a tough day, because there's no trigger. It's not documented anywhere. So when I've worked with families and I'll say, how many days has your child been suspended? You should be able to call school and say, can you let me know how many days my child's been suspended? And they may go, they've only been suspended 3 times this year for 3 days. And this parent's like, no, they've been sent home a lot. Well, were they actually sent home because they were suspended, or if it was a bad day, there's no documentation. So that's why it's very important. But that's a true compliance issue. That is the regulations. At 10 days, the school has to trigger a manifestation determination for that student.
So again, it's kind of maybe feel like a tough call on the parent's part to say, are you suspending my child? And if you're not, then you need to work with him, and he or she needs to stay in school. If you're suspending them, then it needs to be documented. So it does sound like a bit of an emotional kind of a fine line to walk that the parent has to be, but in furtherance of the long-term solution to be able to get the right supports in place, maybe that's what it takes.
Yes,
so
that's it exactly.
Okay. What happens if a parent disagrees with the determination made at the superintendent's hearing? So whether or not the student is guilty of an infraction of the code of conduct?
You can appeal that. You can absolutely appeal. You always have what's called your due process rights, and the school should be sending that to you at the superintendent's hearing. So that really is an appeal to state ed, and they can review it and look and see if it's a true violation of the student's of the school's code of conduct. And again, like I had spoken earlier about the student who was suspended for over a year for bringing marijuana to school, the commissioner reviewed that and looked at it and said the student hasn't been in trouble. They've had minor infractions. It was marijuana, we felt that a 1 year suspension is too long. So they felt that, I think they ended up giving the student a month of suspension for that. Now, bringing in alcohol or drugs will still require a suspension, but there will be some leeway. There may be some leeway to go, okay, we're not going to do a whole year's worth of suspension. We'll just do a month's worth of suspension. I actually worked with a family that the young man had been out hunting and for the weekend, and he came in. He was running late for school, and in the back of his truck he had a gun rack, and they were all locked up, but he had weapons on school property. Now, the school recognized that it was a mistake, but the violation was that the student did bring weapons onto school property, and the young man was suspended for 2 weeks. So what I try to do is, when I work with families, help them also look at some things. For example, that young man, if it was his workplace and they had that kind of a rule, he might have been fired. So getting 2 weeks of suspension versus being fired from your job when you're older is not too bad. A student who brings, let's say, alcohol to school in a water bottle and is caught and is suspended for 2 weeks or a month, I'll say, okay, if they were caught on the street with alcohol, they might be arrested. So we want to start to keep some things in perspective also for our students. If you are a middle school or high school student and you punched a teacher or you punched another student because you became upset and you got suspended for 2 weeks, I want to try to give families a perspective of that we want to teach and help and support that person, because if you become, once you become an adult and you punch or hit someone, you could be arrested, and we don't want that to happen. So we want to start to look at the behaviors and say, what happened, how can we support the student, and how can we get them the supports and services they need to be successful, not only in school, but for the rest of their life.
Okay, yes, so what would be some natural consequences outside of a school setting might be appropriate, or people need to understand that if you punch someone on the street, you could be arrested for assault. So there are a couple questions here around the superintendent, or excuse me, around due process. So the question is, you referred to the Commissioner of Education. Is that the same as requesting a due process hearing? And then due process hearings are generally, I think the question is, she thinks it takes 60 days. What's the timeline for an expedited due process hearing?
Okay. Oh, this one I have to tell you, I don't know off the top of my head. You're right. You're right. I'm talking about two different things. You have a right to a hearing, an impartial hearing, and you can go on the New York State Department of Education, NYSED website, and you can put in the search engine impartial hearing, and you can file for that. And you would file for that, and then it would get sent to the school, and they would bring in a impartial hearing officer to hear both sides, and they would make a determination. If after that you found that you still disagree, you can appeal through New York State Department of Education on their website to the Commissioner of Education in writing, and ask for them to review the case. Now, in some cases, they will actually look at that. In other cases, they'll say, nope, we support the school, we support what the hearing officer said. I don't know, I have to tell you, I don't know off the top of my head what the timeline is. And I wouldn't want to even guesstimate because it might be wrong. But I think if you go out to the New York State NYSED website and look up due process, it should have the exact timeline in there for you.
Okay.
It shouldn't take you 6 months. That's what I guess that's what I could say, that it shouldn't take 6 months to do an impartial hearing.
Okay. And another question comes to my mind with regard to impartial hearings, with regard to stay put, the current placement. If what you're appealing has to do with a suspension, What is the current placement for a student? Is it the tutoring that they've been assigned when they've been suspended, or how does that work?
Okay, so I hope I am understanding this. So is it a student who, let's say, is in a gen ed setting? Let's say they're at your local elementary school. They get suspended, out of school suspension, let's say for 3 months, and they have a superintendent's hearing and the parents disagree and they file a hearing and I think they would I think they would stay put in where they are in 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 the out of school, the tutoring right at that point. But I'm going to tell you it's going to depend. If it's a student that has done its weapons, violence, serious bodily injury, or drugs, controlled substances, um, and they're trying to get them, they may not be able to get them back into their current placement, because of those are the three exceptions where the school has the right to say, due to the nature, the severity of those three, or one of those three things, that coming back would be dangerous.
Okay, thank you. Um, we're going to get into a couple more. These questions are a little bit more specific, but I think the audience members might still benefit from the answer. Um, a child was suspended, and the parent argued that she didn't think the child would benefit from the suspension, but what was told that the classmates and the teacher would benefit. They would need some time to recuperate and regroup while this student was out of the classroom. How would you respond to that? Is that a legitimate reason, and is that what's the way to, if you don't think that the student's going to come back changed or change their behavior, how do you respond?
So I'm going to say that depends, because what I don't know here is what the student did. If the student did something that was violent, caused serious bodily injury, and was very upsetting to the other students, I'm going to say that's going to depend on what the student did. And without knowing that, it's hard to make a judgment. Um, my my personal opinion is I don't believe that well, I don't believe in any student benefits from being out of school suspended, but I do believe in other alternative placements for that student. Um, Again, we've had students that have committed serious crimes on other students, and putting them back into a classroom could be dangerous. So the district should be working with the families to find what would be another appropriate placement. But again, without knowing the details, I'm going to say it depends. And I've had worked in situations where a student attacked another student in the classroom, and it was very upsetting to the teacher and the other students, and there was a suspension. And I think it's almost a deeper detail. There was a suspension because he attacked another student, and they also needed to regroup. So sometimes I see that the student isn't suspended, that the school will say, we need time, we're asking you to keep them home because we need time to regroup and rethink and come up with a plan. There's
Right.
pluses and minuses there
Mhm.
for that. And I would say it depends on the situation. If they're talking about a student who may need one-on-one support and they just need to get a one-to-one aide in and hired, and it's going to take a week, as a family, I'm going to say take it on a case-by-case basis and look at that. I think it's too hard to just look at everything and see it so clear-cut and say it's this or this. I think you have to look at the student, you have to look at the situation and say, are they really truly working to get supports and services in place so the student can be successful? And if we have to hire personnel or bring people in, you can't do it overnight. It's going to take a few days.
Okay. And so everything you've talked about is communication with the student's team, the teacher, the principal, the
Yes,
CSE chairperson. It's going to be essential to making sure that your students' needs are getting met appropriately. And if it's not in the classroom that they were in previously, it may be looking at either additional supports there, a behavior intervention plan, or perhaps a different placement to have the child's needs be met. So
absolutely.
this one's a little specific, but I think, again, it might benefit. A student is being sent to the counselor every day in response to the inability to sit in math class due to ADHD. The school is not responding to the parent's request for notice of the time that this child has been asked to leave the classroom. How can they, what's the best way to get that information?
Well, especially if they're being asked to leave every day, that's a removal from instruction, and I'm a chain of command person, so I believe in talking with the classroom teacher and asking, saying it's my understanding that, Johnny's being asked to leave every day because they're struggling to get through math. Of course, in my head, I'm thinking, well, what kind of supports and services do they have in math, and do we need to look at that? Do they need consultant teachers, some, accommodations? But then I would go to the teacher if you still don't get anything, and I would document. I went to Mrs. Brown on February 22nd. We talked about this. She said she's unable to provide that. Then I would go to the principal. I would talk to the principal. I would document the day that you talked to the principal, what you talked about. If nothing was rectified, then you have a right to go to the superintendent or CSE chairperson and say, this is what's happening. The student is being removed from instruction. They're not learning. They have, so we need to look at that. You could even request updated evaluations from the Committee on Special Education, because I would want to look at why they're being removed every day, because they're struggling. What supports do they need? Do they need, some fidget items? Do they need to sit on a big yoga ball? Do they need more support? Do they need more processing time? What do they need in math? So there's so many other things that come. So there's the chain of command, and then there's also possibly bringing the team in to say, what do we see that the student needs? What are their struggles? How can I support you? What can we bring in to support my son or daughter?
Thanks, Laura. And I'm going to post the link to the SurveyMonkey in the chat pane right now. So those of you that would like to take the survey immediately can do that. There's a couple more questions, but they are very, very specific to a particular situation. So again, I encourage you, if you have questions about your own child's situation or about a child that you're working with, to call our main number, 585-546-1700, and you'll be connected to someone who can then address those individual needs in a one-on-one kind of conversation and get the information they need to be able to provide you with support. So as I said, I posted the link to the SurveyMonkey. I also wanted to say, I forgot to mention this at the beginning, both Laura and I, when it says we're talking, it's always saying that I'm talking. It's because of a little glitch that we have with GoToWebinar, but trust me, Laura's the expert on this topic and I'm just the moderator today. So even though it said I was talking, it was not Pam, it was Laura. So if you have follow-up questions, please ask Laura. Let me also I want to navigate to our website and show you where this webinar recording will appear. And also I wanted to point out, Laura talked quite a bit about manifestation determination today, and we actually have another recording specifically about manifestation determination that's about, I think, maybe 15 to 20 minutes long. So if you find yourself in a situation where your child has been suspended, you're going to have a manifestation determination, and you want to find out more information just on that topic, you won't have to sit through this hour and 15-minute webinar of everything regarding discipline and suspension. You can focus just on that manifestation determination topic. So let me do that right now. Hang on just a second. Okay, Laura, are you seeing my screen that looks like it's on our website? Yep. Okay. All right, so this is the Starbridge website. You navigate to Resources, Webinar Recordings, which takes you to this page. And then here is the topic that you're listening to right now, discipline and suspension. And if you were to click on that link, it says this is where the webinar recording will be posted, as a description of the webinar, and then a link to the slides. If I'm going to go back to the previous page, and here is the link for manifestation determination. So that has a recording, question and answer. There's actually, the Q&A is in written form, so you can print that out if that's helpful. There's the video where it's a back and forth between this is Laura and Kathy Giordano, who is an expert in supporting students with behavioral needs. So they talk in a sort of a dialogue fashion about what happens when there's a manifestation determination coming up. And then here are the procedural safeguards that relate to that, the safeguards for students with disabilities when they are to be disciplined. So I think that kind of wraps up our topic for today. Let me just take a quick look to see if there's any other questions that have come in. And if not, it looks as though all the questions that we're going to handle in a general forum have been answered. So I'm going to thank Laura for her time and thank you all for being in attendance today. If you, again, have individual questions you'd like to have answered, feel free to give us a call or use the Contact Us page on our website. And Laura, do you have anything else you want to add on this topic?
I don't, but I wanted to thank everyone for taking the time to attend. And again, like Pam said, if you have more questions, please call the 546-1700, and then they will, and actually what I will ask is, you probably won't get referred to me directly because I'm in and out of the office a lot, but they will refer you to a family education specialist who can answer or support you with your questions as well. So thank you so much for attending.
One post just came in that someone was having trouble opening the PDF in the control panel. Don't worry about that. The PDF is also going to be on the website. So just go ahead and navigate to that page on our website and you'll have access to that same information. Once I close the webinar, you won't have access to it in the handout pane. So hopefully you'll be able to get to it on our website. And if you have difficulty with that, give us a call or use the Contact Us page and we can get that material out to you via email or some other fashion. So, okay, great. Thanks again. Thanks for joining us, and we hope to see you again in a webinar audience sometime in the near future.